Hi everybody, welcome to another CLAT Tutor Legal video. Today's discussion is on the topic of constitutional law, and we will be discussing the 97th Constitutional Amendment and why the Supreme Court's new ruling strikes down a part of the amendment and thereby also the Constitution. The 97th Constitutional Amendment focused around cooperative societies. The Act itself was introduced in 2011, and Article 19(1)(c) along with Article 43(b) were amended in 2012 with effect from 15th February 2012. What was the amendment? In 19(1)(c), the words "or cooperative societies" were added. So after the amendment, the article read something like this: all citizens shall have the right to form associations or unions or cooperative societies. And they had just amended 19(1)(c). The other subclauses were not touched. Article 43(b) was introduced as a new article which spoke about the state fostering cooperative societies. Now, the state here does not mean each individual state, but it talks about the country or the Union of India as a state. It also introduced Part 9(b) into the Constitution, which is titled the Cooperative Societies. You can Google Part 9(b) and read all the intricacies that were added. But the focus here is why the Supreme Court struck it down and what was the issue regarding division of power and the Indian structure as a federal, state, and union of states. Let's move into the issue. India is known as a union of state. There is a division of power where each state is its own sovereign. Every state in the country, whether that be Karnataka, Andhra Pradesh, Uttar Pradesh, or Haryana, has its own powers to make laws and enforce those laws. Similarly, the country also has its own powers to make laws and enforce laws. As we all know, it is the legislature which makes laws. It is the parliament or each state legislature which does that for each state. And these laws are enforceable within the territory where this legislature or the parliament has control over. So the Karnataka Vidhan Sabha, if it passes a law and if it makes a new law, it's applicable to Karnataka. Similarly, if the Indian Parliament passes a new law, it's applicable to the whole of the country. But then there is an issue. What if two different bodies pass the same law but with different meanings? Which is why the Constitution devises a method of separation of powers with different lists. There is a union list, a state list, and a concurrent list. Now, this is basic. We all know this. And in Schedule 7, the exact items or the exact things which each state or each or of the country has control over is separately defined. But what happened here? The amendment spoke about cooperative societies in this manner, and the definition is given here, which means a society registered or deemed to be registered under any law relating to cooperative societies for the time being in force in any state. And this is the same definition of cooperative societies which entry 32 of the state list covers. And here was the problem. Cooperative societies, as per entry 32, was purely in control of the states. Each state had its own right to make a law. However, the new amendment was a central law, and the Indian government, through the parliament, was trying to change a law which would affect the powers of a state. Now, this is possible because the parliament is supreme to each state. And the only way this is possible is when such a law is ratified by at least one half of all states in the country. So if half the states accept, okay, this is a fair law, we are allowing you to, hamper or infringe upon our powers, we will allow you to make a law which should have been made by us. And after one half of the states ratify this, then it becomes a law across the country applicable to all. And this is given in Article 368 about the importance of ratification and the parliament making laws for each state. For example, the 101st Amendment was about the GST, and tax as a subject is again separate for the state and the centers, and each state has its own powers to make laws on tax. So when the GST amendment was introduced, the same issue existed where half the states had to ratify. And in that case, for GST, half the states accepted the 101st Amendment and then passed their own state GST laws. There is each state has a separate GST Act now. And similarly, this was also important. But in this case, there was no ratification. 17 out of the 28 states at the time did create a new law for cooperative societies, but the ratification as required by the constitution did not happen, which is why the Supreme Court said Part 9B out of all the amendments is invalid. It is ultra vires of the constitution because the procedure has not been followed. This does not mean the entire amendment was struck down, but just some parts of 9B, of some parts of Part 9B were struck down because those parts affected or infringed upon the state's powers to make laws. And the entire case can be read online. It's called Union of India versus Rajendra and Shah. You can Google it, look it up, and just read a brief. But this is the entire focus of why the Supreme Court struck it down. And for our discussion, we will keep it to this level itself. We will not enter further details because that will only get confusing. But essentially, a part of the amendment which affected the constitution changes were struck down because the Supreme Court stated that the procedure mentioned under the constitution was not followed. And that made the part ultra vires of the constitution. For this legal discussion and the 97th constitutional amendment, that's all that we have to talk about today. If you have any feedback, please feel free to write to us at hello@clarktutor.com. And until the next video, stay safe. Thank you.